Chris Johnson, who works in the state crime lab, is on the stand, and objections start flying.
Grounds for the overrule.
Go ahead, sir.
The address for the pieces of mail that I recovered was 4014 North 19th Street, Milwaukee, Wisconsin, 53209.
Thank you.
Objection, that should be strike. When he asked the question, he said he didn't recall, so how can you force somebody to recall?
The witness's recollection was refreshed through the use of his report, which he indicated he documented the address. Your objections noted, it's overruled. The answer will stand. Go ahead, next question, please.
Yes, and actually, if I could back up 1 minute and ask Ms. Gussie to put back up 117. I have to ask a question about 117.
Go ahead.
And if we could display it, please, Madam Clerk.
Nobody got to answer no questions.
Mr. Brooks, please refrain from interrupting. You'll have an opportunity to ask your
I have an
questions
objection
on
of
cross.
how stuff got to the table without my knowledge. That should be known. That should at least be noted for the record.
It was
I wouldn't
noted
be able to do that.
Your objections noted, it's overruled. Go ahead, Attorney Opera.
So that needs to stop happening.
In
It needs
addition
be
to
fair.
that,
All right, I'm going to excuse the jury.
All right, for the jury.
Can't keep doing stuff without. It should be a fair trial. That's my right. You shouldn't be able to do things without my knowledge. And then pass it off to the jury like that's fair. They deserve to know that too.
The rest of you can have a seat as well. As soon as the jury's out, I'll make a record. All right, Mr. Brooks, you are well aware that the reason
consent to being called
documents
that
are
name.
being put on the
I don't consent to
witness
being
stand
called that name.
are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I
You are
merely asked, how did
attempting-
it get there?
Sir, do not
I'm not
interrupt me, or
I'm
you will
not
forfeit your
entitled
right to be
know how it got
present in
there?
this courtroom.
So
Do
you
not
holding me in
interrupt
contempt?
me.
Are you holding me in contempt?
I'm going to make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt.
Do not interrupt me again, or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're going to clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right, no, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit
I'm
anything.
going to start talking, and if he interrupts, then I will close this courtroom, and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody, and I'm not going to allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly under the rules of decorum and courtesy, or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection, that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to SCR Chapter 62, which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04, 1 at 9:05, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05. There was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19, audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35. At 3:06, there was the hilarious comment. At 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you. Again, as I stated earlier, I've even limited how I tell these things to the jury about how to disregard, and I simply say the jury is to disregard comments and statements made by the parties or the lawyers, as those are not evidence. So I'm warning you, do not interrupt again. If this jury comes back, or when they come back and you do that, then you will be removed and you will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses. Okay?
And I'm not stopping you from
Through
doing
your
that.
behavior, you're not going to delay these proceedings today.
I'm not trying to delay the
continue.
proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know
Mr.
what
Brooks,
I'm trying to do.
bringing the jury out. I'm not going to argue with you.
Then don't. Because I'm not arguing with you either. I'm stating facts.
You're raising your voice. It's
because
very
I'm
angry tone,
tired of you
and
always
it's
making a
yelling
record.
At me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not gonna work.
I'm making a record of what's accurately.
You're
being
making
done
a
in my
record of
courtroom.
incorrect statements. That's what you're doing. You're not making a record of
Mr.
not
Brooks,
being
I'm
able.
advising you to be quiet because the jury's coming back out.
You're advising me to be quiet. Is you telling
I'm
me to be
advising
quiet?
you to be respectful when the
Are
jury
you
comes
telling
out.
me to be quiet, or are you asking me?
I'm asking you and advising
Okay.
you.
Thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
We're all
if you
we're
lower
all
your tone
adults
of
in here.
voice
I've
and
never
not yell at
told
me,
you to
sir.
do anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work. I'm supposed to be scared of getting removed or something.
Thank you, everyone. Please be seated. State may continue its examination of this witness. I believe we're on Exhibit 117.
Yes, we had 117. Madam Clerk, would you please turn the display back on? Mr. Johnson, were there other items on the front passenger seat besides the blue winter hat?
Objection leading.
Overruled. The witness may answer.
I do recall a cell phone being present on that front passenger seat.
Do you remember what kind of cell phone?
An iPhone.
I also see some items that look like maybe headphones or charging cable, something like that. Do you see that, sir?
Objection leading.
Overruled. Foundational. The witness may answer. The exhibits have previously been received.
Objection speculative.
Overruled.
I do see that.
Do you remember something like that on the front passenger seat?
Yes.
Okay. And how about on the floorboard of the front passenger seat? Is there an item there, sir?
Objection leading.
Overruled. You may answer.
Yes.
What do you remember that item was?
A TV.
Okay. And to the left of the TV, the white colored object?
I don't recall what that is.
Okay. But this is the exact way the passenger seat looked when you recovered the vehicle, correct?
That's correct.
Okay. Now, if we could please go to Exhibit 116 and put up for the witness only. Sir, do you see Exhibit 116 in front of you?
I do.
Do you recognize this photograph?
I do.
Do you believe this to be a true and accurate depiction of the interior of the SUV?
Yes.
Move to admit 116, permission to publish.
Objection. Relevancy.
Overruled. Exhibit 116 is received. Permission to publish is granted.
What's in the photo of 116, please?
This is an overview of the rear passenger seat. That rear passenger compartment contained several clothing items and miscellaneous items.